Hello, my name is Randall Borden. I'm an attorney here in Virginia, and I'm going to talk today about what you should do if you're not receiving child support. So this assumes that you already have an order. The other side, the other parent, has to pay you child support, and then the other parent has stopped paying. First thing you have to do is to write a good faith letter to show that you made an attempt, or more than one attempt, to get child support prior to going to court. The reason you want to do that is that you want to ask for attorney's fees. So you have to show, in fact, when you file, you have to actually certify that you tried to work things out prior to going to court. And quite frankly, sometimes that just takes care of the problem. The person might have changed banks, the bank might have screwed up, which is more and more common today. There could have been some delay in the mail, some temporary problem with the person's income. You do want to at least give them a chance to catch up, notify them, and so you can show the court that you notified them. Then you would want to file in court what's called a motion for a rule to show cause. And again, you have to have an order, and you have to show that the person is deliberately and intentionally not making the payments. And again, that's another reason that you want to write them or make a good faith effort beforehand. I mean, maybe the person mailed the check and it just got lost in the mail. That does happen. Maybe the bank just didn't mail it out. That does happen. For a rule to show cause, you have to show that the person deliberately failed to make the payments. And again, if you have a series of good faith letters informing the person they didn't make the payments, informing the person that, hey, there's this court order and it says you're supposed to pay this amount of money on the first of every month and you haven't paid for 2 months, then you have a very strong case in court when you file the motion for rule to show cause. The typical way is you have to file an affidavit along with the motion. The affidavit says that you are entitled to this much child support, and you haven't received the child support for this month and this month. At this point in time, the person owes you child support of blank, the total amount. That is filed with the motion. That is an affidavit. The court then looks over the motion, looks over the affidavit, looks over the order, obviously, to make sure that it's all there, and then will issue out what's called a rule to show cause. And that is a order, essentially, an order to the person to show up in court on a certain date and time and explain why he shouldn't be held in contempt. The rule has to be served on the person. You can't just have it out there and the person doesn't know about it. The person actually has to be served with it. And that term service has its own legal definition. So the person has to be properly served, and then the person then comes to court and explains why they didn't make the child support payments. And typically the goal is not to punish the person. The goal is to get the payments back on track. So the person, if they're smart, when they get the rule to show cause, they will get hold of the money somehow and catch up. So then they can go into court and say, Your Honor, I had temporary financial problems, it's straightened out now, or I borrowed the money and the person is, I'm up to date. And then they'll typically dismiss the rule to show cause. Once these start building up, then obviously it's less and less likely that, but again, the emphasis is on getting the money, getting the custodial parent paid, and not punishing the person. But it starts off gradually, the inconvenience of having to come to court. For most people, that gets them back on track. For most people, that solves the problem, and for most people, they don't repeat it in the future. Now, for the ones that don't come to court, the judge can issue an order to take them into custody and bring them to court. The judge can continue the hearing over to another date, giving the parent a chance to track them down and actually notify them that this is serious. The person can come to court and promise to make the payments. That is, in that situation, the most typical response is the judge says, okay, this is the first time you've been here, so I will continue this over. How long do you need to catch up? I want you to make all the payments in the future. How long will it take you to catch up? And if the person says, it'll take me 5 months to catch up, then the judge will say, okay, I'm going to keep this hearing open, but I'm going to continue or schedule the next hearing over 6 months in the future. And then during those next 6 months, I expect you to make every payment on time, and I expect you to catch up on your delinquent payments. And then you would go back to court, and like I said, most of the time things are straightened out. In the event that it's not, then it's really becomes the discretion of the judge as to what to do. Is the person unable to make the payments? They might have lost their job, they might have been injured, they might have a disability of some sort. Is the person just saying, I don't feel like making the payments? Is there some other reason there? The judge really tries to try to get the money to flow, because the whole purpose of this is that the parent with custody needs the money for the kids. They're not getting rich off of child support, and each parent has to do the right thing here. And if you lock up the parent that's not making the payment, they're not going to get any payments. If it comes to it, the judge might take the person into custody for a night, for a weekend, release him the next week, again trying to get him encouraged. I say him, but it's usually the man, not always, to get the person back on track, making the payments. A lot of times when that person comes to a lawyer, the lawyer will immediately file to reduce the child support if there's a good reason. Again, if there's a recession and everybody's losing their job, the business is shutting down, COVID, that kind of thing. So you would immediately file to modify child support based on the new circumstances. That motion would be heard at the same time. So that doesn't excuse the old payments, but it at least gets things back on track. You may have to reduce the child support down to a manageable level, but there would still be the new lower amount, but there'd still be payments, additional payments to catch up on the arrearage on the back child support. If the person is locked up, they want to have some kind of a plan. That's the job of the lawyer. If you're facing a rule to show cause, and you can't come up with the money right away, you want to go into the court with a plan. Your Honor, I understand, I know I owe this money, and here's how I'm going to pay it back. It might be getting money out of your retirement plan. It might be borrowing money. It might be taking a second job. It might be, again, like I say, filing a motion to reduce child support, so something like that. But you want to show the court that you've got a plan so that the money keeps flowing. And if you can live up to that plan, if it's a realistic plan, then the court, like I said, will usually delay the hearing or move the hearing over, continue the hearing, which means move the hearing over to another date and keep track of what's going on in this case. If you're in that situation, you should definitely talk to a lawyer, at least get some advice. Even if you don't hire the lawyer, know what you're facing. I'm Randall Borden, and I hope that was helpful. Thank you.